we go. Two very disparate concepts that don't seem to be at idem with each other, but they in fact are in some very interesting ways in terms of which we can utilize various different acts in conjunction with each other in terms of being able to get the most power we can in terms of getting the maintenance obligations enforced and in terms of getting the best possible financial outlook for people that are finding themselves in a financially distressed situation, particularly when it comes to maintenance type situations where people are struggling and everyone's fighting over money, who's paying enough for the groceries, who's paying enough for the school fees, and all the realities that we have in terms of the maintenance obligations and the enforcement of that. So I'm going to go through a few slides. I'm going to deal with the law that surrounds maintenance as well as reckless credit and how it can be applied in a very practical way. It's pointless us going through slides and reading all the sections of various acts and understanding the regulations that underpin it as well. But it's about being able to understand how we can take the law and apply it in a practical way going forward, because that's the only way it's going to make a difference. Just go back one quickly, sorry. There we go. Okay. The first thing that we just have to take notice of, we have to have the foundation and the understanding of what a maintenance order is and what it means in terms of its enforceability in the courts and when we're applying the law to it. Now, the maintenance order is the same as any civil judgment. It, in fact, has the effect of a civil judgment. That's going to become very important down the line when you look at how we go about enforcing maintenance and what aspect of that also has relevance to the consideration of whether reckless credit has been granted or not. I'm not going to read the sections. You can see it on the slideshow, but that's effectively what it does say. There was also two amendments that was made to Section 26 of the Maintenance Act, in terms of which it stated that when a maintenance order remains unsatisfied for 10 days or longer, one could then reapproach the maintenance court in order to get it enforced. But not only does that happen, that order that is obtained on an unsatisfied maintenance order, that then is supposed to go to the maintenance officer, who then is supposed to take a certified copy of that maintenance order and then provide that with the details of the person that has now failed to pay in terms of maintenance, and that can then be submitted to the credit bureaus and any other parties that are involved in credit ratings. So what I'm trying to say there is, when there's a maintenance order that hasn't been satisfied for 10 days or longer, you go back to the maintenance court, you get an order. That order must be sent to the relevant credit bureaus in terms of which it gets listed there. So in other words, if the person goes and applies for credit, which I will deal with a little bit later, who's now not been paying the maintenance and they now want to buy a Hilux Bucky as an example, and then the bank does a credit check, and then it should be able to see, wait a minute, there's a default listing, there's a judgment on this person's name that he is in arrears with his maintenance. Then that would be a big no-no in terms of that person's credit worthiness in able to access credit. Reason why? If the person's not able to afford his current maintenance obligations in terms of the court order, and also obviously the rest of his credit obligations, then how can he afford a new obligation? And if that bank grants that credit, then they could be at risk of that credit then being recklessly granted if they didn't take into account that the maintenance order or the breaches in terms of that maintenance order that is now been listed on the credit bureaus. In terms of maintenance orders, there's also certain offences that are related to those orders. You can be liable for a fine, conviction not exceeding 3 years. And again, in terms of Section 31(4) of the Maintenance Act, it again states that information and the person's particulars has to be submitted to the credit bureaus or any other body that's involved in the credit rating of persons. But that essentially is always going to be, as it currently stands, the credit bureaus. So there's the various sections in the Maintenance Act that says there should be some serious consequences when orders are granted in the maintenance court in terms of those defaulting payments, that they should be listed on that person's credit profile that would then be of relevance should they try to access credit in the future. But now one has to ask, what relevance does that have with regard to the granting of credit? So what if it's listed on the credit bureau? What does it actually mean in practice? What difference would it make if a maintenance order is listed on the credit bureau or not? Well, it actually has, as I've alluded to earlier, it actually has quite a massive impact on the person's creditworthiness and also on the ability to be able to access credit. Now, the definition of necessary expenses, that relates to what the creditors have to do in the assessment of when they're assessing a person that's now applying for credit. And one of the things they have to look at, aside from income and everything else, is the necessary expenses of the particular person that is now applying for credit. And now, necessary expenses has been defined in the affordability assessment regulations of the National Credit Act. It has been defined to include maintenance payments. So in other words, when you're listing your groceries, your fuel, your insurance, or anything else that there is, it specifically and expressly states that in the consideration of necessary expenses, one must also always include maintenance payments. And again, in terms of Regulation 2312, this is also now in terms of the National Credit Act. It says that when a credit provider is conducting an affordability assessment, it's obviously necessary to look at their income and look at their monthly debt repayment. And then category C is take into account maintenance obligations. So what I'm trying to say here is maintenance is a special category of expenses. It's not lumped in with groceries or petrol or school fees or anything like that. It is a separate category that's expressly provided for in the regulations for a credit provider to consider whether or not they should be granting credit. What's even more interesting in terms of the regulations that deals with credit acts and consumer information is that a civil court judgment will stay on the person's credit profile for 5 years, a maximum of 5 years, or if the judgment is obviously rescinded before that. So generally speaking, any civil judgment will stay on a person's credit report for a period of 5 years unless they're rescinded at an earlier stage. But what's interesting is maintenance judgments are actually treated differently. Remember, right in the beginning of this presentation, I said that a maintenance judgment, a maintenance order is the same as a civil judgment. But in terms of the retention periods of the credit bureau information, a maintenance judgment is actually treated differently. It's actually more powerful than an ordinary civil judgment, because in terms of how long it must be retained at the credit bureau, it says until that judgment is rescinded by a court. So there is no 5-year limitation that after 5 years, it automatically falls off like any other civil judgment. No, maintenance judgments stay there until such time it has been rescinded, or naturally all the maintenance obligations have come to a natural end because the children are now majors and they're now independent, et cetera, and then that rescission can take place. So again, this is another part where one can see the emphasis that the various acts are placing upon the maintenance obligations, that it is treated in a special way, in a special category all of its own, that it even gets retained at the credit bureaus for a longer period of time than an ordinary civil judgment. Also, again, what emphasizing how important is that banks and any other credit provider looks at maintenance as a part of its assessment protocols. In the declaration that consumers must sign and complete whenever they apply for any credit, this is also in terms of the regulations, one of the sections is 3.7 maintenance expenses. In other words, when the questions get put to the consumer, either in writing or asked of them over the telephone, they have to go through every category of what questions must be asked in terms of the assessment protocols, what their income is, all those sort of questions. And then again, at 3.7 of the criteria, the questionnaire that must be put to the consumer, it again specifically lists maintenance expenses. And one can see maintenance expenses, the amount, living with, and then the payment as provided for by court order. So in other words, what that means is when a credit provider is assessing a credit agreement, they must put it to the consumer. Do you have any payments that are due in terms of a court order with regard to maintenance? If they don't put that question to the consumer, or they don't put the questionnaire before the consumer, it's not completed, then that will also be something that will be taken into account when it comes to reckless credit, which I will deal with in more detail shortly. The point I'm trying to make in a very long-winded way is that every step of the process, when it comes to the act, when it comes to the regulations, and when it comes to the affordability assessments that must be complied with by any credit provider, it has a special focus on maintenance as part of that criteria that must be considered. And if it isn't, it can have very dire consequences on various parties, which I'll deal with shortly. I just want to go a little bit further into the assessment criteria and mechanisms that are used by credit providers. This is again regulated and very strictly so, that when a person applies for credit, the credit provider may determine to have its own evaluation mechanisms in terms of the procedures and models it will provide for, but those mechanisms must be fair and objective in terms of the assessment that takes place. And it must not be inconsistent with the affordability assessment of the regulation. In a very brief and simplified way of explaining what that all means, it basically means that any creditor can have their own mechanisms of how they're going to go about assessing a consumer's credit worthiness. But those mechanisms that they have need to be rational and need to be fair and objective. They must be able to back it up substantively that they've granted this credit properly and they've taken into account all the necessary steps and regulations that they have to in terms of determining a consumer's affordability. And they've verified what they needed to verify in terms of the information that is provided by that consumer. Now, Section 81 of the National Credit Act deals with reckless credit. In terms of the National Credit Act, is actually Section 80 to 84, but I'm going to be focusing on just the certain sections that are relevant for the purposes of this presentation. So Section 81(2) specifically provides for what the credit providers may not enter into reckless credit agreements before taking reasonable steps to assess the proposed consumer's general understanding and appreciation of the risks and costs of entering into that proposed credit agreement. What that means is before a creditor can grant credit to anyone, they must make sure that the person that's trying to access the credit understands and appreciates what the consequences are, what the risks are, what it's going to cost, what the monthly installment is going to be, what the interest is going to be, and how long it's going to take in order to pay this debt. So they must be able to understand and appreciate what it is that they're entering into. A creditor must also, they are duty bound to look at the debt repayment history of the consumer that's applying for credit. All that means is anyone that applies for credit, the credit provider needs to access the credit bureaus to draw a credit report so they can look at the debt repayment history of the consumer. So that's where to see, is this consumer up to date with their payments? Are they behind? If they are behind with some of their debt payments, how far are they behind? Are there any judgments listed on their name, etc., etc.? In other words, to determine the person's credit worthiness, it's just not based on what the current income is and what the current expenditure is. You also have to look at their past conduct to see that they've kept up to date with their various credit obligations. Again, very simply put, all that it means is if you're applying for credit and you're not able to service the current credit that you have by virtue of falling behind, then you shouldn't be granted more credit, because it would then be reckless, because you've clearly shown on your credit report in an objective way that you're having difficulty servicing your debt, and now you want to even access more credit. All that would do, it would place the consumer even into a worse position. And that's what we call essentially a debt trap, where a person enters into more and more credit agreements in order to try and pay the old credit agreements, and so on it carries on, and it becomes a vicious circle. And every new credit agreement is generally at a high interest rate because it's now a higher risk. And then they end up being in a situation where all they're basically doing is trying to service their debt and have nothing left in order to pay anything else. And in terms of the assessment, the creditors must also do, they also have to evaluate the existing financial means, prospects, and obligations. That is looking at the income, the expenses, getting the bank statements from the consumer, and evaluating what the expenses are, and to determine whether that person has the necessary affordability to qualify for whatever credit is that they're applying for. Now, the question one has to ask is, so what happens if a bank grants credit and they didn't use fair and objective processes and mechanisms, or they granted a credit and the consumer clearly couldn't afford it, or the consumer, like I said earlier, has maintenance obligations that aren't being met? What would the consequences be of a situation where credit was granted where it shouldn't have been granted? And that's where Section 83 comes in. And this is one of the most powerful sections in any act when it comes to dealing with credit and against the banks. This is a section the banks and the other credit providers, the loan sharks, everyone, this is a section that they're very, very scared of. And what we're going to see exactly now why. The reason why they're scared of Section 83, because it gives the power to any court hearing a matter related with regard to a credit agreement, to set aside all or part of the consumer's credit obligations under that credit agreement, or to suspend the force and effect of the credit agreement. What that basically means is, if you go apply for a loan, and then it gets determined that that loan has now been recklessly granted because it didn't take into account the consumer's maintenance obligations, et cetera, and the bank statements that were provided. Clearly, this was a person that was living month to month and didn't have any more disposable income to service that loan. You can actually go to court and have that whole loan in its entirety written off. So you go get a 100,000 rand personal loan, you can actually have that loan written off in its entirety. It's set aside as in all the obligations. You can also ask the court to set aside part of the obligations. Normally, that would mean that, okay, cool, you've got a personal loan of 100,000 rand, but you received the money, you've used the money. It wouldn't be fair to that creditor that you don't pay, that it gets written off in its entirety. But what we're going to do to punish that credit provider is we're going to order that 100,000 rand loan get repaid without any interest. So in other words, you have to service that loan and pay back that 100,000 rand over a protracted period of time, but you don't have to pay any interest. It's an interest. It will be effectively be an interest-free loan. You can get an order like that as well. Or the last part is suspend, where you don't have to pay the loan for a period of time, 2 or 3 years, and only after the expiry of that period of time, after it's been suspended, it'll come back, and then you have to then service the loan. In other words, if you have other debt you need to sort out first, and once you sorted out that debt, then only this loan will then come into effect, and then you will only start paying that particular loan. I don't really much like suspension, because all it really does is putting off the payment of a loan. I rather prefer that the loan either be set aside in totality, or the interest gets written off, and it can get paid back at a much lower installment without interest being charged. And that is very scary for the banks. Just to let you know, there is case law on this. People's home loans have been written off because of reckless credit. I dealt with a matter personally here in the Western Cape High Court, where amount of 1.2 million rand was written off on a home loan. So we're talking big money here if a bank has been reckless in terms of granting credit. It's not small change. It can be a 1,000 rand loan, or it can be a multi-million rand home loan. And they all fall part of what reckless credit is and what constitutes reckless credit when it comes to the granting of credit. However, there is one problem we have, and this is now where everything I've come back to and everything that I've laid out in terms of the law and the provisions with regard to maintenance, and that it is an order, it has the effect of a judgment, etc., etc. That's where we are now sitting with a problem currently in the practical aspect of enforcing those maintenance orders and ensuring that the wayward maintenance payers aren't able to access credit and run up all sorts of debt, and then go to court at the maintenance inquiry and say, but I don't have any money. Look at all these debit orders running off my bank account. We have to stop that from happening. And the only way we can do that is if there are very serious consequences, if credit is being granted to people that are not paying the maintenance, and all they're doing is running up more and more debt and have less and less money available to pay for with regard to their children and their children's school fees, etc., etc. So the problem we have with this whole maintenance thing, it sounds all great and wonderful, but there is a complete defense to reckless credit, and that's dealt with in Section 81.4 of the National Credit Act. Now, what Section 81.4 basically says is that if the credit provider can show that the person that applied for credit failed to fully and truthfully answer the information, the request for information that was put to that consumer when they applied for credit. In other words, if the consumer lied, when the bank asked, do you have maintenance obligations? No, I don't have any maintenance obligations. Then the bank can show that lie was material. Had they known of that person's maintenance obligations, as an example, they would never have granted the credit in the first place. So if a person that's fallen behind on their maintenance, and that maintenance order is not listed on the credit bureau, and then they go apply for credit, and then they lie to the bank saying, no, I don't have any maintenance obligation. There's no court orders. There's no way the bank can verify that at the moment, because if they've asked the question of that particular consumer, that consumer lied, They look at the bank statements of that consumer. There's no maintenance, or there's no maintenance being paid because this particular person isn't paying maintenance. How would the bank be able to establish and verify that this person is actually has an obligation to pay maintenance in terms of order? They wouldn't. Now remember what I said right in the beginning. There is a provisions in the Act and in the regulation that says that maintenance orders are supposed to be listed. But currently, there's only one credit bureau that I'm aware of that is actually listing the maintenance judgments. And that is a very serious problem. Why it's a problem is because if it's not commonplace, and that if not all maintenance orders are being listed on the credit bureaus, we are going to have an issue with regard to credit providers being able to rely on Section 81.4 and saying, okay, cool, this person had maintenance obligation, but here's the questionnaire that was completed. Here he said 0. There was nothing filled in. And here's the credit report. There's no order on this credit report that is required to pay maintenance and he's fallen behind on these obligations. That is why we have a serious problem. And that is why I'm doing all of these presentations, is to verse the public in terms of what the rights and obligations are, verse the public in terms of giving the information, because information is really power in all of this, on going to court and insisting that the maintenance officer follow the Maintenance Act, as well as the regulations in terms of the National Credit Act, and ask, rather, let's say demand that those orders get sent to the credit bureaus. You've got to understand, all judgments, all civil judgments granted in the Magistrates Court and the High Court, they all automatically, following a certain processes, go through to the credit bureaus to be listed. Why should maintenance orders be any different? They shouldn't, because we've already looked at those sections and said they should be treated the same. In fact, they should be treated even more than an ordinary civil judgment. But unfortunately, in South Africa, maintenance orders in general are not being sent through to the credit bureaus. And if they're not listed, credit providers are going to come all the way back to this section and say, but the consumer lied. And the whole point of what I'm telling everyone in this presentation is, it's important that these maintenance orders and the defaulting maintenance orders get listed on the credit bureaus, because we need to stop these people from accessing credit and running up all sorts of debt, buying fancy cars. In the meantime, they go run every time back to the maintenance court and say, oh, but I can afford my maintenance. If we can block them from accessing credit, and when they want to go buy a new car, and then the bank says, sorry, you're 3 months behind on your maintenance obligations. I can't grant you credit. Otherwise, I could be liable for reckless. This debt could be written off. That would then motivate and incentivize the defaulting maintenance payment to get his house in order. Because if he doesn't, he's not going to be able to get loans. He's not going to be able to get credit cards. He's not going to be able to buy another house. He's not going to be able to buy a new car. He's not going to have any access to finance. If we block them off in terms of accessing credit, that would help massively in terms of motivating recalcitrant maintenance payers to pay their maintenance, because otherwise there are going to be very serious consequences in terms of the ability to be able to finance anything in the future. Now, these two sections that I've been dealing with now, Section 83 and Section 85, are two of my most favorite sections in the National Credit Act. And if you take anything from this presentation, it's these two sections. So if you leave this presentation and you find yourself in your maintenance court next week, in a month's time, in a year's time, just remember Section 83 and Section 85 of the National Credit Act. You're going to understand why I'm emphasizing those two sections now, because I'm going to show you what you can do if you go to court and you know what your rights are and you insist that those rights be enforced. Now, what Section 83 says, it says, despite any provision of law or agreement to the contrary, so no matter what anything else gets said, in any court proceedings in which a credit agreement is being considered, that court may declare that credit agreement as being reckless. Okay, let's break that down. First of all, it says any court proceedings. So this is not just the civil court hearing a bank trying to enforce a judgment on a home loan or on a credit card. It says any court proceedings. So that would include a maintenance court, because a maintenance court is a court proceeding, obviously. And then the second part of it, considering a credit agreement. Now, the word considering is a very broad word. It doesn't say in any court proceedings in which a credit agreement get their money back or to get the car back. No, it doesn't say enforce. It says considering. So what does that mean? Well, when you go to a maintenance inquiry and you go to the maintenance court, you got to on your income and your bank statements and all of that. Now, in most cases, as the father, he's going to go to court and he's going to bring his file and he's going to bring all his statements. Say, here's my credit card, here's my car, here's my personal loan. These are going to be all the expenses. He's going to say, I've been deducted off my salary. Here's or his bank statement. Here's my pay slip. Here's my bank statements. Here you can see I'm getting these debit orders. I only have so much left after my salary's been paid and the debit orders have run off my account. I cannot afford to pay the maintenance that is being requested. So that is where the maintenance court, the maintenance officer, as well as the magistrate, is considering that credit agreement as part of the inquiry, that they have to consider those obligations and take that into account in terms of making a determination as to the affordability of granting a maintenance order and the amount of that maintenance order in question. So, excuse me. What I'm getting to you is this. A maintenance court is considering those credit agreements. It has to. It's duty bound to. It has to look at the existing income and the obligations of both parties in order to make a determination as to maintenance. So what I'm saying is a maintenance court falls straight within Section 83(1) of the National Credit Act. It does. It's considering a credit agreement. It's a court proceeding. So a maintenance court, if they're considering those credit agreements, can actually make a declaration as a court that those credit agreements are reckless, can actually make an order to have those debts written off if the court believes they are reckless. So imagine you go to a maintenance court and then the father comes to the court and says, oh no, I've got all of these credit cards and I bought my Hilux Bucky 3 months ago. Here's the debit order running off my bank account. And the maintenance magistrate can then look at that and say, hold on. You've had these maintenance proceedings here for the last 6 months, saying you can't afford to pay maintenance, but yet 3 months ago, you've now gotten yourself a 400,000 rand vehicle finance for your new Hilux Bucky. You said you couldn't afford this. How is this possible? Then that magistrate can actually declare that Hilux Bucky reckless. And the consequence would be you can have that debt written off. That vehicle will then have to be returned to the bank because the agreement's now been cancelled. It's been determined reckless. That whole debt will be written off its entirety. Now, whatever that he was supposedly servicing on that vehicle over the last 4 months, say he was supposed to pay 4,000 rand per month in terms of his new vehicle finance, write it off, declare it reckless. Suddenly, he has now 4,000 rand more available to pay maintenance because you're going to have that debt written off and that car must be returned back to the bank. That is a sort of power that a court has. That is the power that you have. And when you go to the magistrate's court, when you go to the maintenance court, you can ask the court to conduct an inquiry in terms of Section 83, particularly when you know the other person is living an extravagant lifestyle and he's making loans and credit and not caring about the maintenance obligation. The court can ask, let me see when that credit was granted. And obviously, the more recent it is, the more possible that it is reckless. That's in terms of reckless credit. What's more, Section 85 reads almost the same. Again says, despite any provision of law or agreement to the contrary, in any court proceedings in which a credit agreement is being considered, exactly the same as what you just dealt with. If it is alleged that the consumer under a credit agreement is over-indebted, the court may then refer that consumer to a debt counselor or right there on the spot declare that consumer to be over-indebted. Let me break that down in simple terms. If the father goes to a maintenance court and he says, listen here, I can't pay this maintenance. I have too much debt. This is not fair. This is unreasonable. I have no money left. What is he saying? He's saying, I'm over indebted. He's admitting it. He's saying to the court, he's essentially over indebted. So the maintenance court under those circumstances say, okay, sir, you're saying you can't pay your debts. You say you're really, really struggling. I'm going to make a finding of you over indebted, and I'm going to order that you go either to a debt counsel or I'm going to make a declaration right now that you're over indebted. Now, the question is, what does that mean? Well, the moment that the person gets placed under debt review, they are also then going to be barred from being able to access credit. when the person is placed in debt, whether they applied for it or not. So either they applied for it or by an order of court. That will then, what that will then mean is from that day forward, they will not be able to access credit anymore until such time they've settled all of their debts. All of the debts have to be settled, and only then can they come out of debt review. And then after that, once all the debts have been settled, will they then be able to be cleared from the credit bureaus and then be able to access credit. The point being is this is a very powerful tool for a mother, for children who are trying to get maintenance out of a recalcitrant father. Because if that person's coming to court and saying, I'm really struggling, I've got too much debt, that's fine, no problem. Let's restructure that debt. Let's make sure you pay less. So to give you an example, if a person's debt obligations is the credit cards, loans, clothing accounts, home loans, whatever, vehicle finance, comes to 8,000 Rand. That's what they have to pay contractually each and every month. And you can see those debit orders running off. The magistrate's court, the maintenance court, can then refer that person to a debt counsellor. Debt counsellor can go back to those credit providers and say, listen here, his obligation is 8,000 Rand per month, but we want to restructure this that he only has to pay 4,500 Rand per month. And then go to court and get a court order ordering that those debts get restructured from 8,000 Rand per month in total to 4,500 Rand per month instead. So that would then mean, again, the same thing as what I was referring to earlier. Now suddenly, that person that couldn't afford to pay maintenance now has an additional 3,500 Rand available to them because they had their debts restructured from 8,000 to a lesser amount. So these are various very powerful mechanisms and means that are available that one can go about restructuring debt, having debt written off to ensure that there's more money available every month for that father to be able to pay his maintenance obligations. Not only be able to pay maintenance obligations, to even go back to court and have those maintenance obligations increased because you're improving that affordability by reducing that person's debt obligations with regard to the credit that they currently have. And also stopping them from accessing credit in future so that it won't happen that in 6 months' time, they've restructured the debt and now they can just go back and make another loan. No, they won't be able to. They are kept within that framework of having to settle those debts before they'll be able to access credit in the future. And that's what's probably going to take 3 to 5 years. So that's a very good run in terms of being able to have your maintenance obligations enforced. And remember, once the person settled all of the debt obligations, they will then exit debt review and then they'll have access to credit again. But the point that I want to make then is at that point, in 3 to 5 years, if there's no home loan involved, they will then have no debt except the maintenance obligations. So you can even go back to court then and say, okay, cool. He's now been under debt review. He's paid off all his debt. He's now debt-free. You can go back to the maintenance court and say he has now more money available because he's not even servicing any debt. He has no debt anymore. That is all the things that you can do in a practical way if you know what your rights are and the court is brave enough to use the sections of the act that are available and gives it the power to be able to enforce everything that I'm saying. So I'm going to summarize everything that I've said in a very simple way. If we want maintenance obligations to be enforced in South Africa, and I'm sounding like a broken record, I know, and I apologize, but I'm very passionate about this. If we want maintenance obligations to be effectively enforced in South Africa, we need to ensure that those orders are in the first place listed at the credit bureaus. Again, the reason why is because it ensures that all defaults in terms of maintenance orders will be listed there, and those people, if they are unable to pay the maintenance, should not be able to access any more credit. That also goes to the affordability assessment of being able to take that into account when it comes to restructuring in terms of maintenance order, restructuring debt, and ensuring that more money is available for the children. It's so stupid, absolutely stupid, that a cell phone account of 400 freaking Rand can sit on a credit bureau report. But a child's maintenance order can't. Well, can, but isn't. That is ridiculous. Why should Vodacom and MTN have more protection in terms of what's being listed on the credit bureaus than a child that needs food? It makes no sense. And then in finality, in terms of everything that I'm saying is, if all of these things are put into place and you go to court and you ask the court to enforce the various provisions that I have just dealt with, that will have a significant impact in terms of the effectiveness of enforcing maintenance and in terms of blocking access to credit. And not only enforcing maintenance, going back to court and increasing maintenance, because you're able to alleviate the over-indebtedness of the other party to ensure that more money is available for their children. That is, in a nutshell, everything that I have to say in this regard. As I said, I'm an attorney. I specialize in civil litigation, conveyancing, reckless credit, and debt review. In terms of restructuring debt and all those sort of things. And I have seen how effective these mechanisms are in alleviating financial distress and being able to live a life where the one thing you don't have to worry about too much is your debt and your maintenance, because you're having enforced in the court of law, you have an order restructuring those debt. As long as you're complying with those orders, you can carry on with your lives and live your life as to the fullest. Is there any questions?
Any questions from the floor?
Quintin, Steve here. And
Yes.
first I want to say I admire your passion for this. It's
Thank
great.
you.
I really enjoyed it and your presentation. I just have a couple of questions that have come to mind, and I'll go through them individually. Firstly, often when we mediate, we say, okay, the father, the mother, whoever, the other parent needs to pay an amount of 10,000 Rand a month, for example.
Yes.
And that amount is going to be made up of 2,000 Rand for school fees and 1,000 Rand for the kids' judo and the medical aid, and you wind up with a 2,000 Rand cash portion.
Yeah.
How do we list that on the bureau? Should it be listed as 10,000 Rand or 2,000? And what about the inflation link? Does it get changed every year? Because here I'm thinking of the banks pulling through that amount from the bureau.
Yes. Okay. So in terms, I don't want to get too complicated, but I'm going to have to go in a little bit more detail than I did in the presentation. We have to distinguish between two different things. We have to distinguish between a maintenance order in itself, which is what you're referring to, and you have to distinguish with a maintenance order that's been defaulted on. So certain of the sections that are referred to dealt with when a maintenance obligation is not being met. There's a default, it's not being satisfied. Then it must be listed on the credit bureaus. That's in terms of the Maintenance Act. So then the argument could be made that maintenance orders in itself should not be listed. They only will get listed when there's been a default and you go back to court and you get an order in that regard. I would disagree with that interpretation, because if one looks at the regulations in terms of the National Credit Act, it doesn't distinguish between maintenance obligations that have not been satisfied. It says all maintenance orders must be retained on the credit bureau. So I think there is a valid argument to be made that not only defaulting maintenance orders should be listed, but all maintenance orders should be listed, first of all. Then going back to your actual question, the whole 10,000 Rand would have to be listed, and the order would then also be uploaded. The certified copy would go to the credit bureau. So the inflationary percentages can be built into the order as well. And that can be updated by the credit bureau on an annual basis. It's no different than any other civil judgment in terms of which, as a debt gets satisfied, or any credit agreement, as you fall behind, the balances change, the arrears change. That should be the same. One should have the same flexibility with maintenance orders as well. So it wouldn't just be the cash portion; it must be everything. Otherwise, it's open to manipulation.
Oh, that's what I was thinking as well.
Yeah,
and
that's your first question.
Yeah. If once
Quintin,
Sorry,
Steve, can I just add something there? When we're going to work with the app and people is going to start submitting the information through the co-parent app, there's going to be two types of listings. The one is going to be the current maintenance obligation in terms of the court order. If a court order is going to stay 500 Rand per month, that's a monthly obligation. That's going to be the one listing that once it's been verified, it's going to reflect on the credit profile of the person. And the other type of listing is going to be an adverse listing. The adverse listing is where we're going to list the arrear maintenance. So there's two types of listings, and it can be good and bad. The monthly obligation listing for the maintenance creditor, to call it that, in other words, the person that's going to receive the money will have more disposable income, so they will be able to qualify for that car or home loan or whatever is necessary, because there's more disposable income and it's a regular income coming in. That's the one side. And the other side, on the maintenance debtor, it's going to show that this person has got an obligation. In other words, it's a debt that he needs to pay on a monthly basis, just like your EDGAR's account and your Vodacom account and things like that. But that's why it's so crucial that we get parents to use the co-parent app, because that's the only way that we can keep the information as current as possible. When you go to the app, you'll see that apart from the current maintenance order, sometimes in maintenance orders we will get a clause that say you need to make a contribution of 80-20 towards the educational expenses, or 60-40 towards the educational expenses. Once you've set the percentages in terms of the court order, and you upload this additional expense because the parents are responsible for school fees, let's say it's 80-20 and it's 1,000 rand. The person that's supposed to pay this will get a notification, and vice versa. And there's a complete record of this additional expense, although it's not stipulated on the court order, because the court order say the maintenance is 500 rand, and then there's an additional expense where people need to pay. And that's why we've developed this app for parents, so that we can start building this history, because maintenance is a little bit more complex than just a Vodacom account where you sign a credit agreement, and with this credit agreement, I am going to pay 179 rand per month for the next 24 months. There's a little bit more, it's a little bit more complex. I think, does that make sense to you, Steve?
It does make sense, and yeah, it just ties in with the fact that it's very difficult to. Yeah, I work for a bank, and I've worked on loans and things, so I know that when a person applies, they pull through from the bureau all of your expenses, your so much. So now what you're saying is sometimes it's very difficult. Then the maintenance list on the bureau might be 5,000 rand, but in reality, the person's maintenance obligation might actually be 7,000 rand because of exactly what you're saying. And the credit bureaus won't be able to determine that. So there's still a risk of, the person just putting down the 5,000 and forgetting about the other money that's going to go there. So there's always a risk, but there's certainly a good start in terms of getting it listed and being put onto the bureau, so that the banks have a better picture of the person.
Okay. Maybe I just need to explain that a little bit more. Quintin, I don't want to take over your session.
No, please. You're more than welcome to. I'm happy. I'm happy for the helping hand.
Okay. Maybe just to explain a little bit more. And I'm going to punt Roy Rosa now, because there's a very nice article in Roy Rosa in the February edition, specifically around all of this. And the long and the short of it is, there's 44 registered credit bureaus. There's 6 major credit bureaus. The credit environment was one of the biggest gatekeepers when it came to listing maintenance obligations. Even though the law has changed in March 2015, the regulations has changed, it's never been implemented properly, because the credit environment was not ready to take this information. And the one credit bureau that came forward and said that they are willing to work with us was Consumer Profile Bureau. So they've changed their systems. there was a lot of development done because this is a special kind of debt. Just to give you an idea, normal debt has almost got a lifespan of between 3 and 5 years, and then they take it off the person's credit profile because they don't want to keep people in bad credit. But maintenance is something completely different. We've got Supreme appellant judgments now in 2020 that said that you can recover arrear maintenance for 30 years. In other words, that maintenance obligation, even though it's in arrears, it's going to stay there on the credit profile of that person for 30 years. So the credit bureau environment had to make special changes to their systems to enable them to accept this data and to make sure that it's accurate and correct as far as possible. And that's why we take people through a whole process of verification. We're not just going to, and that's why we've got the social justice maintenance services, and it's a free listing. But we're not just going to take the information and give it to Consumer Profile Bureau and say, there's the information, and there you go. Both parents is going to be involved. We're going to verify what you give us. Both parents is going to be aware that we're going to give this information to Consumer Profile Bureau because it's got to be accurate, up to date as far as possible. At this stage, the credit environment, the credit providers, has got a very big problem because they don't have the information that's necessary to make informed decisions. And that's what we're trying to change with what we're doing here. So it's actually quite a big breakthrough when it comes to maintenance obligations and what we can actually do for families in South Africa.
Yeah.
And I agree. It's a good, as I say, it is good that it starts becoming part of your expenses, at least at the banks.
And the further thing that's going to happen is obviously there's going to be disputes. That's the one side, where the mediators need to be properly trained. And that's where Quintin is going to come in, where you need to be properly trained to understand how are we going to deal with this disputes that's going to come from the credit environment. That's the one side, because there's very specific regulations in the Credit Act. On how to deal with these disputes. So not any mediator will have to, you will have to get the proper training to deal with it. There's timelines and everything that's going to go with it. And that's why we encourage people to start using the app, because that's the starting point and the connector of everything that we're doing here.
Yeah. Well said.
Is there any more questions? Sorry, Quintin, please carry on. I'll keep quiet.
No.
Thank you. Just in terms of the next thing is, once the maintenance obligations are discharged, so my last child has finally finished varsity and they've got themselves a steady job and there's no longer a requirement, I've met all my obligations. Is it then up to me to go to court to get a discharge and for me to get it removed from the Bureau? Yes. It's not something that will...
It won't be something automatic because maintenance orders are generally, it's not supposed to say up until the age of 21 or something like that. It's until the child is self-sufficient. And that could be a moving goalpost in terms of them studying and things like that. So it's about the practical application of when maintenance should be due and payable and when maintenance should come to an end, when the child in question is a major and now also self-sufficient and carrying on with their lives. So if one looks at the retention of credit information, it specifically says there that the maintenance order can only come off on a rescission. So there would then be a duty to go back to the maintenance court and get it rescinded. But that would be a relatively painless exercise because it would obviously be served on the other side. It's not going to be opposed if the both parties are in agreement. and then that rescission order, just like the original order, will then be served on the credit bureaus, just like any other rescission or judgment would be served to remove the listing. And it would be removed within 5 to 20 days thereafter. So that would be the most prudent thing to do. It's not going to automatically come off unless there's a specified period of 21 years or something like that. But that shouldn't be the case.
What we've done at this stage, and when it comes to the maintenance orders, because you can do variations or you can do amendments or anything like that, is we've put a lifespan, an expected lifespan on the maintenance order. Again, we're back to the app, and that's the tool that parents is going to have. That's going to help them to communicate with the credit bureaus and everything. You will not be able to go to Consumer Profile Bureau and give them your maintenance order. There's a very specific reason for that. We're going to take you through a verification process and everything. You won't be able to walk into the office and say, here's my maintenance order, now I want you to do this. For various reasons. I think very soon we will actually talk to you a little bit more about the app and how we want the mediators to get involved, because the whole idea is that the mediators must be ready to handle the disputes that's going to come from this, and the mediators must know people like Quintin when it comes to restructuring the monthly obligations to make provision for that maintenance obligation, which otherwise wouldn't have happened. And it's possible to do it, and it's everything. It's in the law.
Okay, there was another question that was put on the chat, and it's a very good question. The question was, does this apply to spousal maintenance? And I'm gonna again hedge it like I did before. It's also open to interpretation. So the sections that I was referring to about maintenance obligations that are unsatisfied, that specifically refers to children's maintenance. It doesn't refer to spousal maintenance. So that's where the maintenance officer must submit that information to the credit bureaus. But again, I would then have the argument that if you look at the regulations in terms of the retention of credit information, it again says any maintenance order must be listed at the credit bureau. So I would have the argument that would be applicable to spouses as well, not to spousal maintenance as well, not just to children. So that's the whole point. It's like the argument I said earlier. I mean, if a cell phone contract can be listed, why on earth can't spousal maintenance and children's maintenance be listed? The provision is made for in terms of the regulations of what information should be retained by the credit bureaus. And they should be retaining the maintenance orders as even more so than civil judgments. So there is an argument that it only applies to children's maintenance. I would argue it does in fact extend to spousal maintenance as well on the credit bureaus.
It was decided to also list divorce orders, because divorce orders normally cut both ways: spousal maintenance and maintenance for minor children. So yes, it will be applying to spousal maintenance as well.
Any other questions? Come on, people. Don't be shy.
Quintin, one last one. In your section 83 and 85, in your section 83 and 85, where it says the magistrate's court can make a determination on reckless lending, or any competent court, does that mean that the credit provider is not involved, or would the court have to pull the credit provider in as well to hear their side of the story, as it were? Or
very good question. The court generally would have to do that, because I've been involved in many reckless lending inquiries at court, magistrates court, and on a high court level. There's a lot of information that the consumer doesn't have. So if the court's going to make a determination that agreement is reckless, you can't just say, the consumer says, oh, but I gave this information and they granted me this credit and never asked for anything, and I don't know how it happened, but the credit was granted. I hardly gave them any information. You can't rely on the evidence provided for by a person that applied for credit. The court would then have to bring an interdict, and there's certain orders that can be granted in terms of subpoenas, duca statum, those sort of things, to call those credit providers in and to provide the assessment documentation that they utilize in granting the credit. So that would be, okay, how did you assess this credit? Please provide us with your calculations. What documentation do you rely upon? You need to provide that, pay slip, credit report, the 3-month bank statements you received at the time. That's all the sort of information you would have to get from the credit provider. And obviously, if you're going to make an order of reckless credit and have their debt written off, they have the right to be heard. They would have to be present and be brought in and have their own legal representation to go to court and then to argue the matter as to why they believe it wasn't recklessly granted, or to then try and raise the defense of the absolute defense that the consumer lied and show. But the consumer clearly lied here. It's not our fault, and that was material to us granting this credit in the first place. It cannot be done in the absence, definitely not.
Thank you.
All right. Then I think that's about it, people.
That's wonderful. Thank you so much. Is there no more questions?
Oh, we have one.
Joan, please talk to us.
Hi, sorry for being late. We have some trouble with our electricity and the system, so we logged in late. My colleague is with me as well. I just want to know that based on the sections that you've mentioned, that the court can then make the orders and then also get it listed on the credit bureau. But what if there's a default already and the mother goes back to court, or the father for that matter, and the court is still not willing to list the person on the credit bureau? What is that person then supposed to do? Or where can they then go for alternative help with regards to that?
Yes, okay. So first of all, I want to emphasize this again. As it currently stands, these orders, maintenance orders, arrear maintenance orders, they're not, except for obviously CPD, they're not as a matter of course being listed on the credit bureaus currently. So I went through all, you might have missed it, I went through all the relevant sections in the Act and the regulations that deal with the obligation that's placed upon the maintenance officer that they are supposed to provide certified copies of those orders to the credit bureau to be listed against that particular person. But the issue that we have is it's not really happening on a massive scale currently, if at all, except on the ad hoc basis via the app. But it has, we try to build this into something far greater, that it becomes something that's built integrity into the process, that it gets listed as a matter of course. And in terms of doing that, it should never be discretionary of, oh, no, I don't want to list it. I don't feel like listing on the credit bureau. If there's a judgment, it must be listed. If there's an order that the person's in default, it must be listed. It should never be a discretion. It's just like a civil judgment. If you owe Absa Bank 10,000 Rand and they get a judgment, then it is listed. A maintenance order and arrear maintenance should have the exact same effect. In fact, it should be retained for even a longer period of time. I don't know if I answered your question. I hope I did.
No, you did. Thank you very much.
Okay.
John, the long and short of it is that the Department of Justice is not listing the maintenance orders. Although it's all in the law, it's all there, they're supposed to do it, they're not doing what they're supposed to do. And that's why we started this private initiative through the non-profit organization.
Okay.
So your clients can just go to maintenanceorders.org.za, or they can download the co-parent app from the Google Play Store. So it's not up to the courts to list anything. The responsibility primarily is with the parents.
I would argue that there is a responsibility on the maintenance officers in terms of the act, but there's a shared responsibility there, which you need to put into place and enforce.
No, I agree with you, but we've got this legislation now since March 2015.
Yeah.
And it's still it's still not been implemented, and that's why we decided that
Absolutely.
we're going to do it ourselves.
You got to be
And that's
proactive and take the initiative.
yes. So this
Otherwise,
is
the
where
lights are going to go out.
yes.
There's another question on the chat. It asks, it was said maintenance is usually paid till the child is self-sustaining. What happens when the child is the one that has special needs that does not make him or her self-sustaining? Very good question. Quite simply put, maintenance will be listed then forever until the father dies or the mother dies for that matter, or the children passes away. Any maintenance obligations will not prescribe. It will not expire until such time that either the child becomes self-sustaining or there's an order to rescind that judgment. It will then stay there in perpetuity until one of the something bad happens in terms of someone passing away at the end of the day. But then there would still be a claim in the estate. Annika, there's a question here about someone said they had load shedding. They missed most of the session. They would like to know how they can get a copy of the recording. If you can just address that, please.
If it's okay with you, there was also a question about if you will be able to share your slides with the participants. We will make this about.
I'm more than happy to share my slides. Where do I send them to? We can social justice. You can get it from social justice.
Yeah,
no problem.
We'll send it. Yeah, we'll send it from the office. That's fine. This recording will be available, hopefully. It all depends on load shedding, on our e-learning platform, and then we can make it available to you.
Okay. Again, that also emphasized. Someone just said also that they're on a really bad network, so they're really struggling to hear. So they also wanted to know whether the record is going to be available. But you've already now addressed that. Thankfully. Just also, sorry, by the way, you have my contact details. So if you listen to a presentation, I talk extremely fast. I know I do. It's just the way I am. And I go over the law very quickly because I know it very well, and I don't always take into account that people are trying to listen and understand what it is that I'm saying, and by the time they understand the one part, I'm already 3 parts ahead. So my contact details are there. It's also on the Social Justice Forum. If any of you have questions about any of these things, or anything to do with debt restructuring, civil judgments, enforcement of debt, credit agreements, anything like that, you're welcome to contact me, and I'll be able to provide free legal advice. If it needs to go further in terms of going to court, obviously there are costs involved, but rather have a point of call and see whether or not you do require legal assistance, and to know the way forward in terms of what your options are, and then we can take it from there. I'm always available and happy to help. I much to my wife's chagrin, I provide a lot of free legal advice. She doesn't like it, but sometimes people do need help. And I'm a phone call away. I'm an email away. I'm a WhatsApp away. But emails are very bad. I get about 100 emails a day. I don't get through all my emails. So WhatsApp or phone calls are far better. Otherwise, I might miss your email. I generally do, unfortunately.
Fine, you can always send the email to the Social Justice Office. I know where to get hold of him.
Yeah. She emails my wife, and then my wife gets on me.
It's a woman's power.
There we go.
Okay, is there any more questions? If there's no more questions, then I suppose I can just say
yes.
More questions, please talk to us. Yes, talk to us.
Okay, can I speak?
Yes, please.
Yeah. Sorry, this will be the last one. We're saying that the father or the mother is obligated to contribute to the maintenance until the child is self-sufficient. And this is just what's happening in our culture, the colored culture, is that children finish school and then they don't want to go and study first of all, some of them. And then if they do, they don't complete the studies, and yet then they still expect the parent to pay them or to contribute to their maintenance, yet they are not making any effort in becoming self-sufficient. What is then the responsibility of either of the parents?
Okay, that's a very good question. And the answer I have is not a very nice answer. Unfortunately, in our law, a child can be of any age and they can sue their parents for maintenance. So the child can be 45 years old and they can go back to court to get maintenance against their parent. In fact, if the parents are deceased, they can go back to court and get a maintenance order against their grandparents. So the duty of maintenance with regard to a child that's not self-sufficient extends far beyond in any age. But in order to justify that, that they are not self-sufficient and they bring an application to court for that matter, they're going to have to show the court that they've made a proper effort in terms of, I'm not talking about children older than that are supposed to be self-sufficient and then later on come back and say, no, my parents must maintain me. I'm not talking about minor children yet. Under those circumstances, the court's not stupid. Just like if, for instance, if you owe a debt and you've got to go for a financial inquiry at the court, and you say, I can't afford to pay this debt, the questions the magistrate will then ask you in court is, well, what effort have you made to go get a job so you can pay your debt? And then you have to next time come to court and show, here's all my 5 letters. I went to 5 employment places and I applied for a job and I was rejected. I would argue that would be the same for a person that's a lot older or should be self-sufficient but refuses to be. They can't expect to be lying on the couch playing PlayStation and then expect their elderly parents to still support them. That's a completely different scenario. They're going to have to justify why they aren't able to go, I don't know, waiter, there's Uber, there's many different jobs, informal jobs that they can do or upskill themselves. But they're going to have to justify that. But if they are trying their very best and they absolutely just can't get a job and they can show that they've tried, there would actually then be they do have a right to maintenance. They can approach a court at any age for that matter to get that maintenance, to get a maintenance order and have it enforced.
Is there any more questions? Did I not miss anyone?
I don't think so. I've looked through the questions. I think we've got everything. Yeah.
Well, ladies and gentlemen, if there's no more questions, then I would like to close the session. I would really like to thank you, Quintin, for giving your time to the Social Justice Association of Mediators. Thank you for being willing to answer all these questions that's going to come your way. I hope everybody's got a good evening. Enjoy the evening, and we will see you soon.
Thank you very much. I also like to just also finish off and say a few words before we go. We are living in extremely difficult times. We think it's bad now. It's going to get even worse down the line. I've heard some terrible reports about Eskom and where it's going. It's not looking good. So what I'm trying to say is, for those mediators out there, for the members of the public, if you are starting to experience financial difficulty and you get that letter of demand from the bank, don't wait too long. Once the summons comes, there's a lot less options we have available to assist you. If you are having financial difficulty, you have the various forums that you can approach this to assist you. So please, I always hate when the person comes to my offices and says, oh, my house is being sold in the auction next week. I'm like, what the hell do you expect me to do? You know what I'm saying? So it's difficult times. It's nothing to be embarrassed about. It's nothing to be ashamed about. We're all struggling. So when there are financial difficulties, anything like that, please, we're all a phone call away. You have various options. Look at what those options are and be able to make an informed decision at an early enough time that you have the most options available to you. The longer you wait, the less options you have available until the very end where there are just absolutely no options left. Right. Thank you very much. I wish you guys all the best. And let's hold thumbs and hope everything works out in the end. But if it doesn't, well, we'll have to fall back on the law and try and enforce what rights we have available to us to try and get the best results possible for our sake, for our children's sake, for the nation's sake. Just sound like the president. Cheers. Bye.
Sounds wonderful. You need to give us a. You need give us a session on debt rescue and restructuring and what will typically happen with us if we do that, Quintin?
I'll blow your heads away if you go about that. The stuff that you can do, but that's for another time.
Okay. I think I've just invited him for another session, so you will see him soon again. Yes, absolutely.
Yes.
Ladies and gentlemen, have a good evening, and thank you so much for joining us tonight. We will talk to you soon, and we'll see you soon.
Thank you very much.
You.
Stop.